There have been twists and turns and movements basically every day when it comes to the litigation against Illinois' gun ban. And you've got, of course, the federal courts in less than 10 days in the Southern District. 4 cases that are consolidated going to be heard in East St. Louis. We'll definitely be there and bring you the latest in that. We'll talk a lot about that leading up to it as well. The arguments about the Second Amendment and the response from the state about the Second Amendment allegations that the gun ban violates the Second Amendment. That's the federal case. We talked last hour about the state-level case from State Representative Dan Calkins. That's all the way up in the Illinois Supreme Court already, with a motion that was filed late Thursday to have 2 Supreme Court justices recuse themselves because they received campaign contributions from lead defendants in that case, notably Governor J.B. Pritzker giving $1 million to each of these candidates, and even Illinois House Speaker Emanuel Chris Welch giving 6-figure donations to these 2 candidates each. So that case we talked about last hour, but what about the DeVore case that he's got 3 of them, one in Effingham County, another in Effingham County, and one in White County. All of those have temporary restraining orders for, I think, the thousands of people that signed up with DeVore to be part of these cases. And as that case progresses, you've got some interesting things that have developed here. And in particular, let's go ahead and take a look at, if you're not familiar with Judici, it's a court tracking system. And for Effingham County, we can look at some of the recent filings here. You've got, for instance, the state looking to have the case be suspended to a degree. So you've got DeVore filing as well, and the judge there essentially allowing the case to move forward. So back in March 13th, motion of legislative defendants, motion to stay proceedings pending the Supreme Court review of the plaintiff's claims set forth in that case. You've got the judge coming back and denying that and denying a motion to quash. So they're going to actually have a hearing on that in May. But you've got another filing that was made at the Illinois Supreme Court by the state, and it's a motion to hold petition for leave to appeal in abeyance pending disposition of the Calkins v. Pritzker case. So what this is it's the state, at least for my layperson understanding of these types of filings, it's the state requesting that the Illinois Supreme Court come in and halt the proceedings of the DeVore case pending whatever happens with the Calkins case. And this is, they're separate cases. Even the Illinois Supreme Court has argued that these are separate cases because DeVore, he requested to consolidate all 4 of these cases, his 3 cases with the Calkins case. The Supreme Court denied doing that and instead kept the DeVore cases 3 separate from the Calkins case. In the Calkins case, then after the Macon County judge issued a final decision of the merits of that in the county level, it went straight to the Illinois Supreme Court. The Calkins case did. But the Effingham County case, which now has the White County case included from DeVore, that's proceeding forward. And that's proceeding forward with DeVore still looking to get the various documentation that he wants to build a record showing that the way the law was crafted wasn't proper, that the arguments of equal protection by having law enforcement and retired law enforcement and people within the security industry being exempt from the law. DeVore is looking to build a case and a record to show how the argument of, well, these individuals get training, so they're exempt from the law, that DeVore argues doesn't hold water. So he's working to get some documentation on that. But that case has been allowed to move forward, but now the state is trying to block this case from advancing pending whatever the outcome is from the Illinois Supreme Court's case that Calkins has brought forward. So let's take a look at some of this. Of course, you've got the announcement of who the defendants are, background of the case, going through and talking about all of the filings that have happened up to this point and where the case is and where the Calkins case is. The Calkins plaintiffs brought an action to the Circuit Court of Macon County, which included an equal protection claim similar to the one in the DeVore case. Goes on to say that the parties moved for summary judgment, and the circuit court entered a final judgment, which, as relevant here, granted the plaintiff's motion for summary judgment on the equal protection claim. All right, so summary judgment on the equal protection claim. And let alone the unanswered questions, some people still want clarity as to if the Macon County judge in that final determination is statewide or if it's just for the plaintiffs, including the group law-abiding gun owners of Macon County. The state police and the attorney general have said that the state law is still the law, except for those who are impacted by these cases. So moving on. You've got the state in the DeVore filing to the Illinois Supreme Court looking to hold this case from advancing. In their argument, they say the petition for leave to appeal presents three issues: whether the appellate court erred in ruling the respondents will likely succeed in the merits of their equal protection claim, whether the appellate court erred in ruling that the respondents would suffer irreparable harm absent a TRO, and whether the appellate court erred in ruling that the balance of equities favors respondents. So Calkins will give a dispositive answer with respect to the first of these issues, and goes on to talk more about the various arguments they have. Holding this petition in abeyance pending Calkins would not burden respondents or the court, they say. As noted, Calkins is on an accelerated docket to be argued in May 2023. Thus, this appeal would not be materially delayed by waiting for the court to decide Calkins. Wherefore, defendants, petitioners, they request that the court hold this petition for leave to appeal in abeyance pending the court's disposition of Calkins. So you can see that you've got the state, the Effingham County Court, trying to get this thing to slow down for the DeVore case. And since they didn't get that in the county court, they're now going to the Illinois Supreme Court to have them step in. But it seems to be that the recognition is these cases are similar. But even the Illinois Supreme Court, DeVore has signaled that these are separate cases. While they might argue about the issues of equal protection, you've got the Calkins case going further to argue special legislation, which is a similar argument to the equal protections. But DeVore's cases that are combined and consolidated are looking at it at a different angle and getting deeper into the weeds of the arguments and building a case. So we'll see what happens with this particular argument brought forward to hold the case in abeyance, meaning to suspend it until the Calkins case is decided by the Illinois Supreme Court. So fascinating to see these continued twists and turns. I'd love to hear your thoughts. You can always call in live and local at 217-629-7970. We'll take a call. Good morning. You're on WMAY.
Man, I have to tell you, I really do believe DeVore's going to screw this up for every gun owner in the state of Illinois. He needs to leave things alone, go back to where he came from.
You're talking about DeVore or Calkins? Because the online community is split on all of this.
Yeah, DeVore. I think it's pretty simple. If you actually went down and met who the guy is, and you looked at Calkins, you can see who has the actual respectable case. So, yeah, DeVore's going to mess this up for every gun owner. I hope people get this.
Appreciate the call. I've seen comments online, the complete opposite, saying that Calkins is the one that's going to screw this up, at least on the state side. Again, this is the state level stuff. This isn't the federal stuff, all right? The state level stuff, at least with the Calkins case, they're not going to hear that until mid-May with a possible ruling weeks and weeks after that. The federal case, you could get a preliminary injunction in place, possibly a week or so after it's heard, in less than 10 days here, by the federal court in the Southern District down in East St. Louis. So this is the next week or so, 2 weeks, we're going to see some drastic movements back and forth, and whether there's a preliminary injunction, which would be statewide. That would not be just for plaintiffs. That would be statewide. If there's a preliminary injunction issued in the Southern District, and you can anticipate that's going to be appealed to the federal appellate courts, and if whatever direction that goes there, it's going to be appealed to the U.S. Supreme Court. And I think a lot of people observe that, yes, the state level arguments are interesting and important when it comes to equal protections arguments, but it's the federal case which is arguing that this law violates the Second Amendment, where you're really going to see the impacts, especially when it comes to the 14th Amendment arguments. You're going to see the impacts really be statewide if there's a preliminary injunction. So fascinating again to see all of that. And we got another story I want to share with you about a ruling that was handed down several weeks ago concerning the FOID card in Illinois. So stay tuned. We'll get to that. So we've been talking about the case that Tom DeVore has out of Effingham County that includes the White County case, and just looking at the county level, you've got several motions to quash being filed, including the Department of Corrections motion to quash because DeVore's looking to find information from the Department of Corrections about training. You've also got the Attorney General and other defendants looking to quash, including the Illinois Department of Corrections and the Attorney General motion to dismiss the case as well being filed, and all of this at the county level case. But you've also got the motion to have this held in abeyance pending the decision in the Calkins case. So again, that's the state level challenges to the state's gun ban. We've been focusing a lot on this because January 10th is when the governor signed it. And the gun ban impacts what a lot of people argue are commonly owned firearms like an AR-15 or other semi-automatic rifles, shotguns, and pistols and magazines of more than 15 rounds for handguns or more than 10 rounds for rifles, and some of the other things that are being brought up includes the ban on those weapons, but also where people can carry those and the registry that's going to be enacted October 1st. So a lot more to come on all of that, but one thing we haven't done is delve deep into other cases challenging Illinois gun law, and one in particular being reported by GunSaveLife.com. John Bach, we'll have to connect with him or with Thomas Mag, one of the attorneys part of the federal cases against the state's gun ban. But Mag had a recent win when it comes to the Firearm Owner Identification Card. So John Bach with Gun Save Life writes that we warned J.B. Pritzker, Representative Bob Morgan, Senator Don Harmon, and Attorney General Kwame Raoul. We told them if they continue this jihad, he writes, against the gun rights of law-abiding Illinoisans, they would have a lot less gun control in a couple of years than they had before. Well, Thomas Mag won a judgment in recent days that struck down the Illinois law that allowed the Illinois State Police to revoke FOID cards over arrests. So if you, at one instance, got arrested for something, you're innocent until proven guilty, right? You're innocent until proven guilty. But if you got arrested for something, then state police could revoke your FOID card or suspend your FOID card. Well, this case has been brought forward, and reading further from Gun Save Life, says it's been common practice for years. Illinois State Police revoke FOID cards for all felony arrests and even quite a few misdemeanor arrests. And John Bach writing, I've even had people tell me that they've lost their FOID cards over DUI arrests. In fact, that's been one of my prime concerns as a law-abiding citizen who carries. If I smoke some mope trying to grab one of my kids or rob me at knife point and I burn him down, I've always had worries that ISP would revoke my FOID card and leave me and my family a sitting duck to retribution by the perps peeps. Well, folks, not anymore, he says, thanks to Thomas Mag. Thomas Mag works as an attorney out of Madison County near St. Louis, and I have increasingly high opinion of him, he says. He's proven himself very skilled and increasingly experienced to a litigator, Second Amendment litigator. And you've got Bach continuing on talking about the case and all the different cases that Mag has won on these issues. He won the class action lawsuit last year that forced ISP to stop taking on $1 to the $10 fee of FOID cards. Last I chatted with him, he had another similar lawsuit against them for tacking a $3 charge to concealed carry weapons fees. And I believe he may have filed a class action against one of the CCW instructors who is cutting corners to scores hundreds of CCW students who all got their training rejected by ISP, most of which happened after they got their licenses. So he goes on to talk about Mag's case here. And you can even see at Gun Save Life the actual filing and the order that was issued. We'll just go down here to some of the points listed in this order. that it's pages long with the background and how the case was argued and so on. But you get to the order that the judge issued here. Preliminary injunction is granted. The Illinois State Police has authority to deny an application for or to revoke and seize a firearm owner's identification card previously issued under this act only if the Illinois State Police finds the applicant or the person to whom such card was issued is or was at the time of issuance a person who's prohibited from acquiring or possessing firearms or firearm ammunition by any Illinois state statute or by federal law is hereby declared unconstitutional as applied to persons charged with a felony but not yet convicted of a felony. All right, so that's important there. It's deemed unconstitutional if somebody is simply arrested and charged and not convicted. You've got the defendant in this case in his official capacity as Chief of Firearm Services Bureau at the Illinois State Police, as well as his successors in office and successors in authority to administer, are effective immediately, enjoining them from suppressing firearm owners' identification cards, or suspending them rather, pursuant to the law, persons charged with a felony but not convicted of a felony. So again, you can read more of that, gunsavelife.com, where they've got the details on this case that Thomas Mag got to essentially say that you cannot revoke a FOID card simply for somebody being arrested. It's innocent until proven guilty in this country, and something I think a lot of people misconstrue for some reason. But obviously, this is a big issue when it comes to the firearm owner identification card. This does not mean that the FOID card is deemed unconstitutional. It just merely means that the FOID card can't be suspended if somebody is arrested and charged with a crime. They have to be convicted of a crime for their FOID card to be suspended. So just a separate case there in Illinois concerning the FOID card. Again, you can find out more at gunsavelife.com. You can read that story. Maybe we connect with Thomas Mag at some point today to not just talk about this case, but also to talk about the trajectory of the April 12th hearing when it comes to the federal challenges against Illinois' gun and magazine ban. So a lot of twists and turns. The story continues to develop, and we'll bring you the very latest, I promise, here with Springfield's Morning News. I'm Greg Bishop. Follow along, Bishop on Air, Twitter, Facebook, YouTube. You can find segments of the show and even watch the show live. Again, Bishop on Air. Hope to see you there. All right, let's take a break.